Good afternoon, everyone. Let's get started. Thank you for joining us. I'm Josh Parker, a Deputy Director of the Policing Project's legislative team. The Policing Project is a national policing reform organization dedicated to transparent, equitable, and democratic policing. Our legislative team works with legislators and policymakers across the country on a variety of policing issues, including data collection, use of force, pretextual traffic stops, and as we're going to discuss today, removing barriers to officer accountability. When a police officer commits misconduct, there are several ways they can be held accountable. They could be charged with a crime, but we have seen how rare that can be. They can be sued for damages, but qualified immunity and other legal doctrines make that exceedingly difficult. They can be stripped of their license by a state licensing agency or post board, but most states don't adequately fund or empower that agency. Or, as we're going to discuss today, they can be disciplined or fired by their own departments or local police oversight bodies. But police unions and others have snuck provisions into law and employment contracts that restrict those investigations and disciplinary processes. Our model statute, which we'll touch on later in the hour, and our conversation today focuses on these provisions, aka barriers, and how states and localities can eliminate them. Before I introduce our panelists, I just wanted to let you all know that one of our planned panelists, Chief Reneé Hall, unfortunately had a flight delay and is stuck up in the air right now and unable to join. But we are so lucky to have Under Sheriff Sylvia Moyer on the panel, who graciously agreed to step in last minute, and I'll introduce her in a bit. But let's start with Victor Dempsey. Victor, or Vic, is a community organizer at the NAACP's Legal Defense Fund, LDF, and founded his own organization to support and advocate for impacted families called Families Are the Front Lines. Back to Sylvia. Sylvia Moyer is currently the Undersheriff of Marin County Sheriff's Department and formerly served as the interim chief of police in Napa, California, the chief of police in both Tempe, Arizona, and El Cerrito, California. And in addition, Sylvia is a past president of the Police Executive Research Forum, PERF. Last but not least, Stephen Rushin is the Associate Dean of Faculty Research and the Judge Hubert Lewis Will Professor of Law at Loyola University of Chicago School of Law, and author of the article on police union contracts included in the supplemental readings. I think you all should have received a notice, but this webinar is being recorded and will be posted on the webinars subpage of our website sometime afterwards. This webinar is eligible for one professional practice New York CLE credit. Please stay tuned. Kind of towards the end of the webinar, we will announce the CLE code that you need to enter on the attorney affirmation form, and we will also type it in the chat. We will leave some time at the end for a Q&A session. To submit questions, just click Q&A on the bottom of your Zoom screen. And those questions will just go to me and the panelists, not to the other audience members. And if you want to submit anonymously, so even we don't see who you are, you could click a checkbox to keep yourself anonymous. Let me just offer a quick roadmap before we start. We're going to start by discussing the state of police accountability and talking about some of the barriers I've alluded to, and then we'll discuss potential solutions at the local and state levels and how to achieve them. Okay, let's go. Vic, we hear a lot of concerns about police accountability from advocates and community members. From your work and experience, what is your sense of the state of police accountability? To what extent is there an issue with officers being adequately disciplined when they engage in misconduct?
Oh, that's a very debatable question, Josh. And I say that because, while in the past few years, some folks can debate that there has been some progress across the U.S. around police accountability, but there are significant challenges that remain still. When we talk about disciplinary actions or just like discipline for misconduct, it's been inconsistent. There's inconsistent discipline that happens But officers involved in misconduct are not always adequately disciplined. Factors like internal investigations, legal protections, and public perception contribute to this inconsistency as well. Even when I think about officers where we want to have kind of this public perception of trust, so to speak, or when wrong is done, then we'll be outright and transparent about it and try to figure out how not to allow it to happen again. But a lot of times, even in that process, we're actually up against legal and structural barriers, right? What agency wants to have a bad apple on their team? And unfortunately, we see it time and time again. When we think about the legal framework of that question, it often makes it difficult to hold officers accountable. And there's kind of like a high bar set for criminal charges and convictions against officers. And that could a lot of times result in few being held responsible for their actual actions. The average community member, we know right or wrong. If an average community member committed a crime, then you would suspect or assume law enforcement will get involved and hold you accountable. But if a law enforcement agency enacts on that same kind of act, a lot of times the bar or the standard, the burden of proof is completely different. And unfortunately, I learned all too well in my own fight for my own brother, who was unfortunately killed by an NYPD officer a few years back. And one term that kept coming up and trying to figure this out was MOS, stands for member of service. Even though he was a plainclothes officer, the burden of proof was almost on us to show the wrongdoing. So there's a lot of issues there around misconduct accountability. But I also think, for me, it's always been the legal structure barriers, but also public perception and trust. A lot of times we get high profile cases of police misconduct, especially those involving more excessive force. We can look at George Floyd, for instance, and everyone's seen that. And that erodes that public trust, and then there's an outcry. And sometimes we get those larger cases that kind of get that attention, and it's on the department directly. So as I mentioned, I've seen some states where they have been somewhat progressive, but true policing transformation, it remains elusive.
Thank you for that. That's really a great start to our conversation, Victor. Really important context. Sylvia, I'd like to ask a similar question for you. You've served as a police chief in different jurisdictions. You're currently the undersheriff. Do you feel that officers are always adequately held accountable when they engage in misconduct?
Well, Josh, I bristle against always. Of course, I'm going to rise up against that. And I think it's really important for folks to understand the perspective that I have and what I bring to this conversation. I'm currently the undersheriff in Marin County, California, on the north side of the Golden Gate Bridge. That is interesting because it's in California and we have statutes that prescribe a number of police actions. It's also interesting because I am the one that reviews all complaints and discipline. I author findings and notices of intended discipline, and I'm a hearing officer for those employees that want to rise up against the discipline and some other things. I also, for everyone on this webinar, I also was a chief of police in Arizona. And in Arizona, there are different statutes, different rules and peace officer bill of rights and different certification. So what I want folks to know right at the beginning is that I have 36 years in the business, and I'm bringing perspective from California and Arizona. So that may help folks understand the perspective. So to answer this, the culture of an organization can't be ignored. However, statute is very prescriptive in California. 832.5A requires that each department or agency in the state of California, which employs peace officers, establishes a procedure to investigate citizen complaints against personnel of the department and provides a number of mechanisms for folks to file a complaint. We can get into some of that nuance later, but I think folks may want to jot down things like Penal Code, California Penal Code 832.5A, and some others that I will cite. I will say that in my time, Josh, I have found that the executives that I have worked with and surround myself with there's not one of us that despises bad cops more than good cops. And those of us that are have the roles and responsibilities of executive service and consistently safeguarding people at the same time we are engaging in public trust and accountability. We hold officers accountable to the very strongest standards. So while I won't say always, I will say that I have seen in my experience firsthand and as a firsthand witness that officers are held accountable to the standards that our community deserves and expects from all of us.
Thanks, Sylvia. And yeah, we're going to talk about kind of, you referred to Arizona being a little different because they have a law enforcement officer bill of rights. Part of the tension here is in some states like that, a chief might want to discipline an officer, but is inhibited from doing so or inhibited from conducting an investigation because of provisions and things like Leo Boers. But let's kind of dive into that. So Stephen, you've written a ton about police accountability issues. Could you just I'll start broadly, then we could get more specific. Why aren't officers consistently held accountable by law enforcement and oversight agencies when they engage in misconduct?
Yeah, so first off, thank you so much for having me here today. I'm a great admirer of the policing project, and it's an honor to be included on this panel. So, my work in this field has talked about a number of different issues, but one thing that I've written about consistently is the process of internal discipline used in police departments across the country. So my choice to focus upon this in my research was actually in part motivated by the fact that I grew up in a household where I had law enforcement members in my family. And when they would talk about the reality of what they were worried about when it came to punishment for wrongdoing, it wasn't the kinds of things that we talk about as law professors or academics. It actually wasn't always Section 1983 suits or, the exclusionary rule or something like that. What was going through their mind was concerns about the internal disciplinary process, how that would work, the options for appeal, were they held responsible, and then what that meant for their career. So I've really tried to kind of focus a lot of my research on those, I think, understudied areas of police accountability, at least in the law professor world, to bring attention to them and to really think through, how we can ask ourselves whether or not the state of those policies really do match what would be our ideal best practices, whether they're a fair balance between officers' protections of their procedural and fundamental rights as employees against the need of a city or a county to punish an officer whenever their behavior may deem them or make them seem unfit for that role. So that's kind of where I come at this question from. The one other thing I would add here is, it's difficult to actually offer an answer about what is the current state of affairs in policing, because we have 18,000 decentralized or so state and local police departments. We're not a nation of one police department. We're a nation of thousands of individual, often very different police departments. Culture within those departments and policies within those departments, they can vary so much place to place. So I think that makes it very difficult to offer a real consistent answer to it. It's also why, some of my work has been trying to figure out, across the wide variety of departments, do we see some patterns of things that seem to be coming up time and time again that can be barriers to accountability. So on that last point, you asked, why aren't officers punished? This is by no means the only reason. It's more complicated. There's a lot of stuff going on. But one thing I've talked about in my work is, we have across the country, as you have already mentioned, law enforcement officer bills of rights. Those exist in a substantial minority of states, but still a substantial number of states have something on the books that we could call a law enforcement officer bill of rights that establishes procedural protections when an officer is facing discipline that often go above and beyond what are given to other public employees. We can debate the relative merits of the procedures that are offered over the course of our discussion, but that's one potential barrier. The other barrier that we could talk about is, as you mentioned in my article, I'm not the only one to write about labor contracts and the way they can impede accountability. Several folks have done excellent work on this, including Campaign Zero. But basically, one thing I've argued is I really do think that occasionally those labor contracts, when they are addressing issues of discipline, may sometimes impose protections of officers' rights that I think go beyond what's necessary to protect them as employees. and actually can occasionally serve as barriers to reasonable investigations. And they impede the ability of a city, county, et cetera, to conduct those investigations accurately, and in some cases punish officers. The last thing I'll say is, I think we also got to frame this not as a problem of the union, because you got to remember those agreements didn't write themselves. They are something that the cities or counties, et cetera, had to agree to and sign on to, which I think makes this an even more complicated question.
Thank you so much for that, Stephen. And yeah, just for folks who are not totally aware of kind of police union contract negotiations or collective bargaining agreement negotiations, the parties to that are the municipality and the police unions. So that's kind of frames why Stephen's saying, look, it's not just the police unions, it's your elected officials in the city or the mayor's office or whatnot. Could I ask you, Stephen, to just give us some examples of barriers to accountability that are commonly found in state laws or CBAs?
Sure. So I'm happy to talk about the ones I've written about, but I want to start off with a disclaimer that a lot of these are my personal judgments. And I think there's reasonable room for people to disagree on what is a protection necessary to ensure fair investigations, fair outcome, et cetera, for an employee versus something that goes beyond that and becomes a barrier to accountability. So I've talked about in my work, I think occasionally when law enforcement officer bills of rights or collective bargaining agreements, et cetera, establish a rigid or long waiting period prior to a supervisor or internal affairs being able to conduct an interview with that officer. I think that can impose an unreasonable barrier at times. There's numerous examples across the country where officers are given access to evidence, in some cases, the entire evidentiary file that they basically have against or in that case, prior to conducting that interrogation or that questioning or interview process. I think that can impose what I view as an unreasonable limitation upon what's necessary to conduct adequate investigations. There's also a number of agencies that provide for a fairly short, in some cases unreasonably short, period when the investigation must be complete. Not to downplay the importance of something akin to a statute of limitations to ensure speedy adjudication of complaints. But if that period becomes too short, and then the period for actually interviewing the officer becomes too long, then it really does shorten the period of time that an organization can reach a resolution and find all those facts. I've also written a little bit about things like the appellate process. So this is very much in the weeds. But I do think, again, coming from the background that I come from, it matters a lot. So I've written about, the procedures that establish appellate processes when an officer is found responsible for professional misconduct. And then what that appeals process looks like if they want to appeal, and then potentially, if they were fired, get their jobs back or have their discipline reduced. That also varies a lot by state and by jurisdiction, but I think it's another area of tension where you could make an argument that occasionally these rules and regulations established by the contracts or by the state law may go beyond what is just necessary to protect the officer as an employee.
Thanks, Stephen. Yeah, and there's actually multiple kinds of provisions related to kind of appeals of discipline that we find. One of the most concerning ones is this is written into law in a couple of states' LEO boards, and sometimes is found in collective bargaining agreements, where a chief, like former Chief Moyer, imposes discipline, but then the law says, no, you can immediately appeal the discipline to a panel that includes maybe a majority of law enforcement officers who are selected by the officer who's under investigation. That is not a system that is employed for any other public employees and is really a barrier. Stephen, you touched on this, but look, there's other public employees that have unions negotiating kind of CBAs. We have teachers, we have nurses. Do you have a sense of kind of how these protections compare to the protections that they are receiving?
Yeah, so one thing I've learned to always be careful about is to not assume anything and not state something on an area that's not your area of expertise. I am not an expert on those other areas of law, so I really can't say. But what I would add to the conversation here is I think we have to independently ask ourselves whether or not the job that police officers engage in, the level of responsibility we give them, demands a somewhat different standard of accountability. Officers, when they engage in professional misconduct, can leave an individual seriously injured or dead. It can have much more significant consequences for those that are impacted by misconduct by a police officer, which is not to say that I'm not understanding fully as the child of a former police officer. I'm fully understanding of the reality that most officers are doing their absolute best, and that job is what's going to put food on the table and help them provide for their family. But my view that I've kind of tried to espouse in my work is we have to not just try to say, is it the same as other professional, civil servants, et cetera? To me, the question should be, given the level of responsibility that we give officers, the significance and importance of their work, how does this level of protections fairly balance their need for procedural protections with the community's need to hold officers accountable and ensure those that are unfit aren't just kept on in the department indefinitely?
Thanks so much, Stephen. Let's bring the questions back to Vic and Sylvia. I'll start with Vic. In your work or your advocacy on behalf of your brother, have you encountered any barriers similar to the ones we've discussed, similar to the ones that Stephen just talked about?
Yeah, I have. I mean, wow. As folks know, it varies state to state, right? Depending on what protections they do have, depending on who is working within the law enforcement benevolent system and things of that nature. It truly varies. But some of the things that I've encountered specifically, back in New York, dealing with a police commissioner, and trying to substantiate charges. And I'm talking about not even the criminal proceedings, right? In my brother's case, the officer was indicted for the murder of my brother. Unfortunately, we went through the trial process and he was acquitted. Sorry, guys. The officer was acquitted for the murder of my brother. And that's actually the impetus for me becoming an organizer. During that time, I realized throughout the trial process, understanding the terminology, understanding what's being spoken about in the courtrooms, it mattered to me. Understanding these definitions, again, like I mentioned, member of service, right? MOS. I had no clue what that was prior to all of this. But throughout that time, after the acquittal, we started moving forward with CCRB recommendations where they did substantiate that there was some wrongdoing based on the law enforcement's own patrol guide. You know what I mean? And after that time, I started looking into so many other states as I started meeting other families who suffered traumatic loss as mine. And then I started seeing the differences state to state. I started seeing the level of, what's the word I'm looking for here? I'm sorry, I kind of got tired. I wasn't
Accountability, is that what you're thinking?
No, literally, the level of accountability varied state to state to state. I came in here wide-eyed thinking that, hey, this guy murdered somebody, whether officer or not, he should be held accountable. But the standard and the burden of proof was completely different. And when I say that about New York and that police commissioner, right, I'm still awaiting a hearing date. But even in Jacksonville, earlier this year, my work led me to looking into a local ordinance that was passed, I believe January 10th of this year, that will require the city to get approval from constitutional officers before settling lawsuits, right? And some folks look at it like, hey, that makes sense. But now when we talk about a sheriff's department, the local sheriff there, he has say in whether he's going to substantiate these community complaints or not. Now, if it's not, then they go to trial. But to give that type of authority to one individual person, yes, he's the sheriff, I get it. But for one person to make a decision and say, hey, we're not going to substantiate that complaint. So there is no day in court. There is no pursuit of justice. There is no accountability, so to speak, because one person decided that it's not going to happen that way. And I will go a little bit further just to say, it's not just the local law enforcement department. It's the tax collector's office, the property appraisers, right? All of these folks get say into if a claim is substantiated or not. But for myself, just going up against that and not understanding how one person is going to interpret language, right? There's no standard there. It's one person's interpretation. So yes, we can have all of these procedures and things of sort to kind of say, hey, this is what would happen if and when something egregious happens. But at the end of the day, how can I argue with one person's perspective? What's the standard there to say, is there a committee that's going to look at it? Is there an oversight behind that? How do we create something that will at least give community members, the same folks who put a lot of these sheriffs in office. It's a voting process, right? It's a democratic process. How do we believe in that level of transparency when we can put someone in office and they have the last word? They're the
Right.
in the beyond of things. So yeah, it is unfortunate, but that's what we've been up against, and trying to figure out a way to identify all of the issues across the nation is very rough. But to Stephen's point, we got 1,800 different law enforcement departments, and it's hard to identify which ones are being more progressive or up and coming, or which ones actually want to hold themselves accountable.
Thank you so much for Victor. I think that really, what you just said supplements some of what Stephen said, because he identified two common sources of barriers. One's in state law, in Leo Boer's Law Enforcement Officer Bill of Rights, and one's found in police union contracts, collective bargaining agreements. You just identified a third class. One's found in municipal ordinances. Not every municipality is going to have them, but a bunch do. And that Jacksonville ordinance you reference, to kind of just put it even differently, what it says is when there's a misconduct complaint that comes in to the agency, the sheriff unilaterally can just dismiss it without even going through any process, without doing any investigation, and say, we're not settling this, we're not investigating this. This is what that ordinance said. So that really speaks to the power of municipal policy in addition to CBAs and state laws. Sylvia, let me turn back to you. You know, as a chief, I just kind of love to hear your view on a couple of the barriers that, you know, Stephen and Vic have mentioned. So let me start with one, which is one of the most common ones, which is long waiting periods before initial interviews. So like, let's say there's an officer who shoots someone, maybe they violated the use of force policy and laws, maybe they didn't, but there needs to be an investigation undertaken. There are CBAs and Leo boards that say you cannot, as a chief, interview that officer for 3 days, 4 days, maybe even as long as we've seen up to 30 days. What's your view kind of on those sorts of waiting periods?
Sure, thanks for that. Look, we are informed by statute, and the Peace Officers Bill of Rights in California says that the interrogation shall be conducted at a reasonable hour, typically during the officer's regular shift. There has to be a notification of the officer. They have to retain counsel. We can look up all the provisions before we interrogate an officer. Here's the real honest answer of what I found. And I must apologize to all my attorneys. In order for an attorney to represent an officer, I found the longest delays are so that counsel and the officer can consult. They can review whatever evidence is going to be presented. And that has been my experience. There have been other experiences that I've had that the delay is really because of the trauma involved in the interaction. And that's a very real human necessity. I can't really speak to long delays outside of those that I've offered. I can say that access to evidence and consulting and preparing for an interrogation have been the primary delays. And those are not because of the police or sheriff's office. It's because of a statute and because of the attorney and client, I guess, provision. I would say that there's this other piece that I think is really important and not explored as significantly, and that is what happens with an officer and the trauma of an interaction. We, I think, are at the infancy of understanding memory and recall and how neuroscience is informing the accuracy of an interview and content. And that, I think, at a later time needs to be explored even more significantly. So I think that's what I would offer at this piece.
Thank you. Vic, I'd actually like to get your take briefly on kind of long waiting periods and delays, since you've been on the other side of it from Sylvia.
Yeah, you know, I really appreciate Sylvia's taking this as well. But again, being on the other side, we talk about long delays and thinking about how an officer feels with a traumatic experience. It's been 8 years since my brother was murdered. My brother was murdered July 4th, 2016. On a holiday that most people celebrate and cook out and set off fireworks. You know, unfortunately, we've had the endure the brunt end of that, right? Where we don't do any of those things anymore. But for 8 long years, and the one thing that I know a lot of folks that I engage with today, and they always say that they remember vividly, and I didn't remember it until I seen it in the newspaper, is during the trial process, when I got that acquittal verdict, I said to someone, my brother was just murdered twice. So witnessing his murder, going through a trial process where I thought there was going to be accountability, and now waiting an additional 4 years just to get a departmental hearing. So when we talk about long waits and that traumatic experience, it's been a lot. I mean, I'm blessed to be in a position here and be able to do this work and to find some common ground and meet amazing people like you all so we can have better understanding. But yeah, the same way these officers are dealing with traumatic experience, we're talking about communities and families that are distraught, and we don't have any authority to come into any place, or so I thought we didn't, right? But to come into a place and just try to continue to fight, that anguish is unbearable. But we got to do what we got to do to figure out a solution for everyone.
Thank you, Vic. That's a really helpful context. And I just add on waiting periods that, if you take a look at our model statute, we say some level of waiting period for an initial disciplinary interview is acceptable, usually up to 24 hours. So if you have a union rep or you want to have a counsel present, you can contact them, let them know about the situation. What we're really talking about is not short 24-hour waiting periods, but there's CBAs that say, look, you can't talk to the officer for a week. And at that point, the social science evidence shows there's more likely to be memory lapses. There might be evidence that's spoiled. And there's the issue, with, to the extent that the officer has early access to the evidence and is reviewing witness statements, it gives some officers time to come up with exculpatory accounts. So the answer is not to say there's no waiting period at all, but there are serious problems when you have a really extended waiting period like that. And as we'll discuss later, our statute prohibits those sorts of waiting periods. Great. I want to talk now about kind of our second group of questions, which is we've identified a bunch of barriers, and literally a bunch. If you look at our statute, we have probably 10 more that we didn't discuss here. We only have time to discuss so much. But I want to talk about solutions. How do we remove these barriers at the state and local levels? Have any jurisdictions, eliminated them at the state or local level? And I'm going to go back to Stephen for the first question here. Stephen, starting at the local level, what are some steps municipalities have taken or could take to remove some of the barriers we've discussed so far?
Yeah, so a really important question. Before I provided my answer, I did want to add one, I think, additional layer of context to our earlier conversation. I think what you pointed out, Josh, the not taking issue with some of the more I would view as humane limitations upon interviews of officers. I'm in the same boat. In fact, one of the things I try to mention in my research is, there's a lot of discretionary judgments about what is a fair, humane protection that every employee should have versus what is like something that impedes reasonable and fair accountability inquiries. So to me, I think some of the things that Sylvia mentioned, like, limitations upon the length of the interview, the conditions of the interview, no objection at all. The other additional, I think, layer of context here that makes it more complicated that I'm sure many of the attendees who may work in local government understand is if you're going to conduct an interim officer to talk. If you compel an officer to talk against their will, that raises issues if that could be charged as a crime in the future. So that does create a more complicated series of kind of decisions that have to be made. So I didn't want to leave that point unaddressed because it really does make it more complicated. So in terms of what municipalities can do or what localities or states can do to kind of combat this, if we view this as part of the problem, there's a lot of options here. I'll mention a couple. So on the more extreme end, we've seen places like Maryland and Washington, D.C. take pretty significant steps to remove discipline and procedures for discipline from the collective bargaining process, effectively saying, going forward, whenever we interpret terms and conditions of employment or something like it in the statute for collective bargaining rights, we are not going to allow that to include discipline, basically. We're going to give that back effectively to the municipality or something like that. That's one option. I think that creates a policy question we got to think about, which is like, is that the right way to go to like limit the ability of a police union and a city to negotiate over discipline at all? Other recent efforts that we've seen is, some jurisdictions have kind of pulled back some of the more significant limitations upon supervisor discretion during discipline through the collective bargaining process, but that requires renegotiating whenever the next cycle comes up. And we've also seen, in terms of appellate discipline, something I've written about a lot, there are examples of kind of modest tweaks made in places like Minnesota and Oregon that I think are also worth mentioning. So in Oregon, they've tried to create a system that alters the standard of review whenever an arbitrator hears an appeal of discipline, while also putting a burden upon the local governments to affirmatively negotiate like a disciplinary matrix to provide better procedural kind of transparency about how discipline will work in advance. So that's an example from Oregon. And Minnesota, they've established some requirements upon how arbitrators are appointed, their training, et cetera, before they hear appellate cases in police discipline matters. So, it's hard to give like one answer to what is the way this could be approached, but really just it's whatever a state or locality thinks is best to try to override in some cases what the state may view as a bad deal that some localities have entered into.
Thank you, Stephen. And I'm just going to add one to the list, a local reform that's more process oriented, but could have substantive impact, which is there's a number of cities that have opened up where they have passed ordinances that open up CBA negotiations as open meetings, or to draft when they're renegotiating a new CBA. They'll make the draft available for public comment. There might even be a hearing before the city council votes to approve it. And this is a significant difference we see in different jurisdictions. There's some jurisdictions where CBA negotiations really are behind closed doors, actually a lot of jurisdictions, maybe in the mayor's office. And then there's an increasing number of jurisdictions now, like just in New York where I'm based, Ithaca, Buffalo, and Syracuse does this. Outside of where I'm based, Chicago, Louisville, Portland, and San Antonio do this. They do what I just described, where they publish the draft CBAs, open it to public comment, there's a public vote on it. So I would urge, if to the extent there are kind of city folks on this call, or kind of community organizers or community members on the state level, pay attention to when the law enforcement CBAs expire and engage with renegotiating the terms. And I'm going to highlight some of the readings that are in our supplemental CLE readings that we circulated that should be able to help you. The Policing Project, we prepared a red flag checklist, and you could just go through that checklist and see, okay, are any of these red flags that impede accountability in this collective bargaining agreement? LDF, Vic's organization, also prepared a fantastic police union contract toolkit where they reviewed over 100 police union contracts and identified the specific language in those contracts that's problematic. And of course, Stephen's police union contracts article actually does something similar in that regard. These are all really good resources. And of course, you could reach out to us at the Policing Project directly if you're in the midst of renegotiating and want, an opinion on how the provisions are looking, and we're happy to help. Vic, you've advocated for police accountability reform at the local level in different cities. You just talked to us about that, Jacksonville, New York. What advocacy strategies work best and or worst? Put differently, how would you suggest going about advocating for the reforms that we've been discussing?
Wow, that's a good one. I mean, to be honest, advocating for police accountability reform at a local level, it can be challenging, but highly impactful as well. I've seen that impactfulness. We talk about cities like San Francisco. They've launched a crisis response teams to respond to like behavioral health calls and Louisville police. Berkeley voted to limit law enforcement involvement in low-level traffic stops. A bunch of different cities have done different things, is what I'm trying to get at. And I think when we talk about local level strategies, trying to figure out what's going to be more effective is really about community engagement. I think every community is vastly different. As a lot of us has already mentioned, what local policies look like are also vastly different. But I think for the first thing, as an organizer, what I do is a lot of my colleagues, we build strong relationships within the community. We want to understand how policing impacts them in their day-to-day, not just in isolated incidents, not just in egregious acts or high-profile murders. Day-to-day, what does policing look like in those communities? And the only way we can actually get solid answers is really building strengthened, strong, sustainable relationships with community members. Another thing that we try to do is look through data transparency, advocating for collection of public recording of data on police interactions, use of force incidents, community complaints. That can also help build trust with communities, just to know, like, hey, if I'm going to ask a question about what's not working and what's working, we want our local law enforcement agencies to be forthright with that information. It should not just be an internal process for folks to make decisions where they're not the ones being impacted by those decisions. Building campaigns around public policy advocacy as well, grassroots mobilization. These are all strategies that we try to do. And again, even when I say grassroots mobilization, that looks completely different depending on what grassroots organizations are around, their capacity, what's happening. Unfortunately, a lot of times current events, it changes the lay of the land every single day, right? As we can imagine. But I think I do want to highlight the policy advocacy piece, because a lot of work that I've done, I've always had to team up with some kind of policy person to figure out what changes are actually available to us. But working with local government officials to draft and implement policies that essentially promote accountability, like body-worn camera mandates, and use of force guidelines. These are things where we have to build that community trust again to do the public education and make sure community members are actually retaining this information. But I also think too that the last part to that is back to the grassroots mobilization aspect. Is I always tell folks, it's one thing to organize, but it's a whole different ball game when you're trying to mobilize folks, right? We can do all this work and then not have folks show up to kind of have that anecdotal material so folks can actually see it. But that's just a few of the tools in our toolkit, so to speak.
No, thank you. I know there are many tools, so I appreciate you highlighting a few. Before I ask my next question, I just wanted to talk a little bit both about our model statute and some other state level reforms we see. We've seen a number of states who have either repealed recently their law enforcement officer Bill of Rights or reformed it, kind of taking out or moderating some of the accountability impeding provisions. Maryland, which was the first state to have a LEOBOR, repealed theirs. Louisiana moderated theirs a bit. Rhode Island moderated theirs a bit. So at the state level, that's in those states, 20-something states that have law enforcement Bill of Rights, that's effective advocacy. And something else that's even discussed is kind of the DC and Maryland approach, where they say you can't cover discipline at all. You can't negotiate discipline at all in your CBAs. And I'd just like to highlight that we actually take an alternative approach in our model statute, which, unlike DC and Maryland, doesn't completely remove police discipline from collective bargaining, but instead it identifies and prohibits some of the most common barriers found in CBAs and local laws, like the long waiting periods, like early access to evidence, like having chief disciplinary decisions reviewed de novo by a group of officers. And our model statute also has kind of affirmative complaint provisions for agencies, to the extent that that's not already in state law, saying, look, if someone calls in a complaint or emails in a complaint, that's okay. It doesn't have to be brought to the department on paper. There are CBAs that say they have to be sworn, so you have to go to a notary. We say that can't be a requirement. Even an anonymous complaint, as long as there's sufficient verifiable information about the incident and where it occurred, so they could, the law enforcement agency could know it, those should be processed too, just like any other complaints. And our statute has language providing for those things. Sylvia, some opponents of state level accountability reform that we're discussing have said that removing protections like week-long waiting periods or limitations on complaints, like I just discussed, would expose officers to unfair discipline or arbitrary discipline. How would you respond to that?
Well, I have to start with discipline is designed to correct or improve performance. Punishment is tantamount to abuse. So we engage in accountability and discipline. I would say that there are there some great examples out in the environment? And that would be, so to describe this, the cascading kind of responsibility and statute framework that exists where I serve right now in California. The California police chiefs went before the legislators in Sacramento many years ago to talk about peace officer revocation certification. It was met with a number of obstacles. And so it was a big no, where police chiefs wanted higher accountability and higher authority and breadth to actually hold officers accountable. At that time, there wasn't the political appetite to engage in that. It later became what is now SB 2 in California that addressed certification and revocation. Also, Assembly Bill 1185 has sheriff's oversight as part of a statute. And I could tell you in Marin, we are engaged in thoughtful, meaningful, high accountability sheriff's oversight, and that is just taking hold in California. I also have to say that in Arizona, it's a right to work state, but there were electeds that put language into bargaining. There were provisions in bargaining agreements that most executives rise up against, but it is an easy win and has a lot of complications in many ways for the language provisions in bargaining agreements. I think our electeds, our elected officials really need to write that. So that's a point. I also think that there is a very interesting piece that Vic brought up. And we have addressed through Barry Friedman and his exceptional work with the NYU School of Law and the Policing Project, talked about police are not the right and appropriate societal actor to address the array of issues that land at their feet. And they make errors, they make mistakes. There are a number of reasons that give rise to misconduct and to poor performance. Our responsibility, and I'd just like to kind of conclude with this piece, the rights and authorities that are granted to police officers are unlike anyone else in government. The right to use deadly force and to deprive someone of their freedom. Those are significant and consequential. And my hunch is that's why many of the provisions provide kind of greater breadth for protections with police officers. It also suggests that those are the very reasons that we need to hold our officers to a very high standard. The loss of trust in the community should never be overlooked. And the fact that officers often not only violate statute, but policies and procedures cannot be, I think, overwhelmed by the fact that there are officers that operate outside of the values of the organization. So I think what I'm saying to kind of wrap this up, in California, we enjoy statutes that say that there are no means by which we will not accept and investigate a complaint. A complaint of misconduct in California and in the Marin County Sheriff's Office will be accepted by any means. We have guidance in English and Spanish, and we will accept it in person, online, anonymous, a number of means. So many of those barriers are removed. So I'll just conclude there and wait for my esteemed colleagues to put a finer point on what I offered.
Thank you so much for that thoughtful answer, Sylvia. Okay, it's CLE code time. The CLE code is Leobor 2. That's an L. I'm going to type it in the chat as well. That is LEOBOR and the number 2. There's an attorney affirmation form. I'm also going to try and put in the chat right now LDF's toolkit, Stephen's article on police union contracts, and our model statute and resources, and the attorney affirmation form. Okay, those are all in the chat. We actually have a lot of questions. We are not going to get to all of them, but we will get to some of them. And thank you for all of you who submitted these questions. There's one I could quickly answer, so I'm going to answer it quickly. It says, when there's a waiting period, is the accused officer prohibited from talking to any fellow officer witnesses? Usually, no. That's part of the problem. You know, there have been consent decrees and you know, policies where separation is required, but I would say that happens in the minority of cases.
Josh, I'll interrupt
Yeah.
since I raised my hand with a little icon.
Yeah.
In California, there is guidance and a directive where officers cannot and shall not, and they're subject to subsequent discipline if they discuss it with others.
Yeah. Stephen, there's a question for you that might be interesting. Could Stephen talk about the difference in CBAs with line officer unions versus management unions in their impact on how investigations are conducted?
Yeah, it's a good question. Without taking up too much time, a couple of things to keep in mind. Whenever I was talking today about some common things that I and others have found in our own independent inquiries into union contracts across hundreds of departments, I believe in almost all cases, we are all talking about the contracts that regulate rank and file officers, not management. So most of those efforts don't look actually at management contracts. I actually haven't considerably looked at them, so I would not feel comfortable, like I mentioned with my earlier comment about not trying to, hypothesize on the content of contracts for teachers or someone else that I haven't looked at. I would not feel comfortable saying anything about that. But I will say, one other thing that didn't come up in our discussion today are like some of the other downstream consequences when a department is unable to remove an officer that they believe is unfit for duty and thus shouldn't have a weapon, shouldn't be on the street, et cetera. One downstream consequence that we should consider is, officers who have been accused of professional misconduct that involves dishonesty. They're now Brady officers, meaning that, if they're going to testify, then we're going to have to provide, if you're the state, information upon their previous misconduct that could speak to their trustworthiness. That creates an odd situation where an officer can be rehired, forced back onto the force, and then a police chief or police executive has to figure out some way they can deploy that officer that's not going to impede their organizational mission, ability to, do what they have to do for the community, because that person maybe can't testify going forward. So it's just one of many examples of more complicated downstream consequences that we didn't quite get to, but I would also say is worth highlighting before our discussion concludes.
Thank you so much. That's really, really, really helpful. Very good question I'm about to read. This might be best suited for Stephen, but Sylvia or Vic, if you have views on it, feel free to weigh in. The question is, time after time, labor agreements with law enforcement employee unions contradict or undermine the express terms of local and state laws designed to advance accountability and transparency. In many states, courts have upheld terms in such agreements that directly contradict provisions that are contradicted by the law. Don't we need clarity in state law in many states that ensures the provision of a state statute always prevail over those in a labor agreement, at least in this area?
Yeah, it's a great point. Others, I forget off the top of my head the exact article citation, maybe we can provide it afterwards, but I know others have been working on this exact argument in our field, basically talking about public policy and when a contract goes against a stated public policy of the state and thus should not be recognized as acceptable, even if the locality negotiated that issue away during collective bargaining agreements or in the CBA. So I think excellent question. And there is, I believe, research out there on those who have looked into it in more detail and kind of developed more coherent responses than what I just gave.
Just because this is less a question, but someone pointed out, Baltimore has an unofficial do not call list of dishonest officers that prosecutors don't call to testify. That actually relates to some barriers we sometimes find. One that we've seen, and then I think Stephen and LDF both noted this, we see in collective bargaining agreements, is it'll say, you can't change a law enforcement officer's responsibility or discipline them in any way based on them being on a do not call list. And look, it's perfectly reasonable to say, and a do not call list, for those who don't know, means, the officer testified in court and maybe gave misleading or false testimony a number of times, and the prosecutor office decided they're not reliable witnesses, so they're going to have a policy of not calling them as an officer. So look, law enforcement agencies might have a reasonable interest in saying, we will also conduct our own investigation to confirm that the officer was making false or misleading statements. But when there's a blanket kind of policy saying you can't even consider do not call lists when talking about a officer's job responsibilities, that doesn't make much sense, even from a total law enforcement perspective, because let's say an officer is on the street and makes an important arrest in a violent crime, then he can't testify about it, or she can't testify about it because they're on a do not call list. So that's another example of a barrier. Let me see. Another question. A few more minutes.
Josh,
Yeah.
I actually see a question I would love to respond to, if that's all right.
Yeah, sure. Read it and respond.
Yes, it's by Dr. Well, the question is, what can impacted families look forward to after attending this webinar? As an impacted family member, this furthered my understanding on why officers and departments get away with murdering innocent people. It's saddening to know this is how the system was set up. The reason why I really wanted to answer that question is I promise you I have the same exact sentiments, and I do this work knowing that it's an uphill battle. I do this work knowing that there are hurdles. I do this work knowing that there are tons of provisions and, you know, CBAs that prevent a lot of officers from being held accountable. But I also have seen the other side of it. I have seen progressive police chiefs, police commissioners that want to sit down with folks like myself and other family members across the country that look for solutions. And this is not me pacifying this. Again, I've suffered a traumatic loss. I'm a chef by trade. I never thought about organizing in my life. I will be completely honest. And I'm not laughing because it's funny. I'm laughing because this is how I deal with the trauma, even now in these types of conversations. But I'm optimistic that the work that we are doing of trying to change the mindsets of legislators, policymakers, even law enforcement agencies, that this is not how we should be operating within our own communities. I can never get my brother back, and I do want to share that for fun. I can't. I don't do this work to get my brother back. I do this work so my children, my neighbors don't get the same phone call that I had. My son is not organizing in the same seat that I am today just to see some change for himself. So yes, how do we walk away from a webinar like this? I've learned in my time after sitting through that trial, and like I mentioned earlier, feeling like my brother was murdered twice, I needed to educate myself to understand what I'm actually fighting. So I love doing these, and again, thank you, Josh. Thank you, Sylvia. Thank you, Sylvia, for even the work that you guys do. Because even though sometimes it might look like there's differences, it's not. I'm doing this work for understanding. I'm doing this work to teach my own communities how to better advocate for themselves so we can get further away from seeing these tragic incidents and egregious murders. So again, thank you for your question, and that definitely touched me. But I'm not going to say this is the means to the ends, but I'm encouraging everyone, take some time out and educate. Take some time out and join these fights. Take some time out and join these campaigns and folks like ourselves who are actually trying to fight and change these legislative processes.
Thank you so much for that, Vic. Before we close out, Sylvia or Stephen, any closing remarks you'd like to make? No need to. Okay, well, thank you to all our panelists. Unfortunately, we're out of time. Thanks so much to Vic, Sylvia, and Stephen for their thoughtful insights in this conversation. And thanks to all of you attending for taking time out of your busy schedules to join us today. For any of your policing reform, legislative, or regulatory needs, feel free to email our legislation team at legislation@policingproject.org. I put that in the chat. I also just put our legislative team website in the chat so you could see the various policies and explainers and statutes that we have. We're always happy to help or connect you with experts like Sylvia, like Stephen, like Victor, if you need some community organizing help to get you started. Sylvia, go ahead.
I was just going to say that I offer my email address. You can put that out so that folks that have follow-up questions or want to challenge me on something, absolutely put that out. I give you my permission, Josh. So thanks.
Great. We'll send an email after this webinar. We'll include contact information, and I'll be sure to include your email.
We have a lot of work to do, so thank you for this convening.
Awesome. Okay, well, thank you everyone so much, and have a good rest of your afternoon.